everyone. Welcome. Today is January 23rd, 2020, and we are meeting to enter into deliberations on our 2019 Comprehensive Plan update. Attending are Commissioners Duncan, Brooks, and Filios, and I'm going to ask our attorney, Pat, to please lead us in the Pledge of Allegiance.
Wow, twice in one day.
There you go.
Maybe it's that booming voice I get when I have a cold. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. I'll just make some brief comments, and then I'll defer to Director Callahan if he'd like to make any. And again, these are deliberations. We completed public testimony a couple of months ago. We've continued receiving public comment. Some actually came in today, which is fine, and I assume have read everything. And so once we conclude these deliberations, we potentially will be voting. And any one of a number of things can happen. We can accept the update as presented. We can make modifications. We can reject it. And at this point, before I go any further, I'm going to ask Director David Callahan if he'd like to make some comments.
Thank you, Mr. Chair. Good evening, everyone. I would just ask you to stay mindful that you can make changes, as in wordsmithing changes, but in my view, you shouldn't be doing wholesale changes that would meet the level of substantive, because then you should send it back to the Planning Commission. Is that a fair assessment?
If that were the case, it could be sent back to the Planning Commission, or the board could schedule another public hearing on it. I have two comments related to...
Please, go right ahead.
Related to comments that we've received late, and in some cases there were repeats of earlier comments we've received. We had one from Kootenai Environmental Alliance stating that the comp plan update would be defective because the analysis in the 2010 comp plan that they acknowledged would still be there with the updated comp plan if it were adopted is not adequate to for the new goals, objectives, and policies that are proposed that are under consideration tonight. I don't agree with that assessment. I certainly recognize that some of the data in the 2010 comp plan, particularly with respect to population and economic development, is outdated, and we will have to update that. That and the rest of that part of the comp plan is proposed to be considered at a later date. Again, first through the Planning Commission, then to the Board of County Commissioners. But I want to emphasize that that does not preclude adoption of the comp plan update tonight that is before you. The second one is from the Coeur d'Alene tribe. It's along similar lines, saying the update would render the comp plan inconsistent with the Land Use and Development Code, and that it would require amendments to one or the other to make them mesh, and specifically that there aren't separate goals, policies, or objectives with respect to each land use designation. Now, as far as those land use designation specific goals, policies, and objectives, I think that is something worthy of consideration should the board desire to look at that issue. And personally, I think there's some merit to doing that, but I don't believe it would render the comp plan inconsistent with the Land Use and Development Code. The zoning scheme that predated the Land Use and Development Code is still there, was incorporated into it. The future land use map from the 2010 comp plan is actually quite consistent with the zoning map, even as it existed back then. Therefore, I do not believe adopting the comp plan update before you tonight would not let me start again.
Go ahead.
Adoption of the comp plan update would not render the comp plan inconsistent with the land use code or vice versa. I think it's still, they're still support each other. They would still be generally consistent, which is what Idaho law requires, not strict compliance with the comp plan. And that also applies to the consideration of the analyses that would remain in the comp plan but be reorganized into an appendix.
Any questions for Pat? I have one.
Not yet, but I may have some later.
Okay. I do have one, Pat. Are you saying that adoption of this plan, the update, does not or would not have any implications for zoning? Doesn't do anything to change the current zoning?
That is correct.
Okay.
It's simply changing the goals, policies, and objectives that are in the comp plan now to what is proposed if you were to adopt it. Doesn't change the zoning at all. The comp plan is not law. The land use and development code is. And so only the comp plan is up for consideration tonight.
Okay. As long as we're on that, I guess I should ask one more question regarding the 2010 plan, and maybe this is something we take up as a board, but the question arose about rendering it, if you will, as an appendix. Now, there are some who say kill it, basically, but the discussion that we had previously was to consider leaving it as an appendix. Is that a decision that we ought to be making tonight, or are we going to proceed under any assumptions with regard to the 2010 plan?
That would be part of what's under consideration tonight. My advice in that regard, though, would be to keep it because it does have the analyses of each element that's specified in statute that the goals and policies don't have. The analyses still support the goals and policies as required under state law.
Okay.
So I would strongly recommend that those be retained, and my understanding is that they would be in an appendix, and I've actually completed a draft of the comp plan that would break out the goals, policies, and objectives that are consistent of the update, and then an appendix with the analyses of each element that's required by statute to include the land use designations that end up in the future land use map, and then the land use map itself would be broken out into a separate section. At least that would be staff's recommendation, to emphasize its importance and to make sure it doesn't get lost in the middle of a large appendix.
Got it. Okay. Any other questions? Not yet? Okay. So how do you want to proceed? Who would like to go first? Or should we go section by section? You have any thoughts?
I don't know, Bill, do you want to?
I'm open. I mean,
Okay. Why don't we start then, we'll try to have some method here to our approach. Let's start with pages 1 and 2, if you will. And I'll throw some things out just to get us started. Let's start off with the proposed objective number 1, general. And we're going to try, from my perspective, I don't think we need to go through this word by word, but as we look at the various sections, if any commissioner has a desire for change or questions or whatever, whether of each other or staff, we can certainly do that. Under the proposed objective, and I'll start it off, recognize the primacy of owners' rights to use and control their property and all regulations and policies and justifying limitations on these rights. I do have concerns with the word primacy, and I can go into that a little bit without belaboring it, but one of my concerns is when you have primacy, you are beyond challenge. And under that consideration, and let's look at it on a practical level, if I'm sitting on 5 or 10 acres and I choose to dump oil or antifreeze, it's my choice. I have primacy. And that's where I think we get into serious trouble. And let me go one step further with the issue of primacy. Here's the deal. The property rights, when you get into the whole property rights objective, the founding, and these are some notes I made, the founding fathers considered property rights important. However, they were in disagreement on primacy. The issue of primacy actually came up with John Locke because he basically talked about life, liberty, and private property. But Jefferson, when we fast forward, if you will, to our founding fathers, changed it to, and was it later adopted, as life, liberty, and the pursuit of happiness. And so they also felt that life, religious freedom were also primary. John Locke in his treatises mentioned life, liberty, and property rights. The founding fathers changed it, as I said earlier. Locke and the founding fathers were knowledgeable of the bundle of rights from British law, and the bundle of rights is what we embrace in this country, which is the right to acquire, to dispose, to encumber, and for quiet enjoyment, okay? And so owners have the right to purchase, mortgage, sell, and I mentioned all of that. So what I would suggest here, to keep us all out of trouble, is to change the verbiage here, to remove the word primacy, because I think it's going to get us in trouble, to fundamentally important, or something that stresses the actual essence of property rights. Thoughts?
I would agree. The word primacy, I think, carries a lot of meaning that is not necessarily intended. The average person reading that might not understand what that means.
Leslie, any thoughts?
I like the word primacy. I'm fine with keeping it. The oil example, it's already against the law. We already have laws against that. So to assume that using the word primacy negates all obedience for laws now or in the future, I completely disagree with.
Okay.
Mr. Chairman, if I could
Yes, sir.
just, chime in, if the language would be a change, I think I would suggest something like fundamental importance or fundamental nature, something along those lines.
I'm fine with fundamental importance.
I am too.
Leslie, you still hold to primacy?
Yep.
Okay, 2-1, fundamental importance. Okay. Does anybody have any comments on number 2? Okay, I do. Tailor land use regulations to reasonably address. I would remove the word narrowly, but just to address nuisances. We have laws on the books to do that, but we're saying here narrowly address. I think when you get into the adjective of narrowly, is somebody yelling or are they screaming? And I would rather not, get into the situation of having to grade it. So I would remove the word narrowly and leave the rest.
I would argue to keep it because nuisances are incredibly subjective. And so when you're talking about a nuisance, we have to have some agreement or definition, because what is a nuisance at my house may not be a nuisance at somebody else's house. That may be extra nuisance at another person's house. So I feel that narrowly, accurately indicates how we should look at nuisances.
I think narrowly is just absolutely superfluous and is not needed in that sentence.
So you're for removing it?
Yep.
So my narrowly is out. Okay, item number 3, protect the rights of, by the way, I'm only citing those that I might have a particular concern about. So, anyway, protect the rights of property owners to the greatest extent possible by maximizing the land uses permitted by right in each zone and minimizing conditional and prohibited land uses. Any thoughts there?
I think that the conditional use process can sometimes be problematic, so I'm fine with leaving the wording the way it is, because when you just say, okay, this zone is not going to have these kinds of things, I think it just cleans things up a little bit. I don't see a problem with it.
Bill?
Now, I had a question.
Go ahead.
As far as maximizing land uses, I had highlighted here, permitted by right in each zone. Can you talk about that, Pat?
Are you asking about what land use is permitted by right are?
Yeah. What
They're the ones that are they're called out as permitted in the Chapter 2 of the Land Use and Development Code without needing any other land use permit, like a CUP or a special notice permit or administrative approval.
But what is it if you say land use is permitted in each zone? Is that sufficient, or do you need to say by right?
I believe by right is the better term because it specifies that no additional permits are required. Land uses permitted in each zone could include the ones permitted by right, the ones that require a land use permit, like a CUP or et cetera.
Okay, thank you.
Yeah, my concern here is the inclusion by maximizing land uses. So if I have a residential development and I want to maximize my land use by initiating a truck depot, is that appropriate? I would say most people would argue it's not. I mean, you can maximize, I mean, I can erect the replica of the Empire State Building with that verbiage. So I'm thinking that, okay, to the greatest extent possible, but I would remove by maximizing the land uses permitted.
I look at this as a guiding document. These are not laws. These are not things that we're saying that when somebody comes before us with an application that we're using our land use and development code. So to continually go through line by line and saying the worst case scenario, I think is not appropriate in this case.
I don't think we're looking at the worst case scenario. I think what we're saying is that we're opening up the door here to potential abuses. And all I'm saying is that we can achieve the same thing by leaving it by relegating the language to the point where it's reasonable. Bill, your turn.
Well, how would it be if someone came in if we eliminated maximizing the land uses?
Mr. Chairman, may I interject? I think we may be losing sight of what the Planning Commission was trying to accomplish here. I believe the intent had nothing to do necessarily with maximizing or minimizing. What they were trying to get at is shifting our great number of conditional use permits to become more by right by having known standards. So it's a shift in how we would, I'm thinking of a proper name, but right now, Pat mentioned to you by right, which is a good term of art that planners have used that I know of since at least the turn of the last century. And the Plan Commission's just kind of up to here with all the myriad conditional use permits we have. They'd like to see things more, or at least the snapshot in this time, more of by right in nature, but not necessarily creating more impact on the land. Does that help?
Somewhat. Pat, did you want to opine?
Oh, I agree with David, and I think some good points were made by all three of you. One possible alternative could be saying by increasing the land uses permitted by right, and then saying and decreasing conditional and prohibited land uses.
Say that again, please.
Substituting increasing for maximizing and substituting decreasing for minimizing. I think it expresses the same sentiment, just not to
I'm good with that.
as much of an extreme.
I'm fine with leaving it the way it is, maximizing and minimizing.
Bill?
I like the suggestion that Pat made.
Okay. I don't have any issues with item 4. Did anybody want to take that up?
No, I have an issue with item 1, but we can finish that paragraph if you got more to,
Oh, did we skip over it?
yeah.
Oh, go ahead.
All right. When you're talking about determining public outlooks on property rights, I get concerned that, once again, we're going to have something that strays away from original intent and that is very subjective. So, to me, that's problematic in this kind of general guiding document.
Well, that's unfortunate because that's exactly what the Plan Commission is trying to get around, is to make it less of a moving target and more of a known entity of what the community wants.
But if the majority of the community lives in cities and they decide that all the counties should look at the way the cities do,
That's another time, another issue for another time. We're really just trying to get policy in place here.
okay.
Well, it's actually looking down, I think Objective 2, Policy 1 would address that, because it specifically calls out, based primarily on the concerns articulated by those who own property within the unincorporated area
Right.
of Kootenai County.
Yeah, actually, I'm glad Leslie took us back to number one, because one of the concerns I have with number one, while we can consider the public in the process for determining public health, safety, and general welfare have actually been given to the state. And we as county commissioners or mayors or city councils are acting as agents for the state. So if it's incumbent upon us to take on that responsibility, how does the public come into this? Outside of the fact, of course, that they're providing input as we go through the process.
Well, I think I can maybe
ahead.
provide a possible answer, at least something to chew on this. I think that's something that any city or county naturally has to do in determining what their land use regulations are going to be and their zoning scheme. You know, each community is unique and each community is different. I mean, even, you know, nearby, you know, close by communities like Coeur d'Alene and Post Falls, you know, Athol and Kootenai County, you know, we're maybe next to each other, but there are different concerns that, you know, that would need to be addressed. And I think, you know, the input of the public, I think is critical. I think that's how we ended up with a more property rights minded land use and development code, as well as getting all the, you know, different ordinances regarding land use into one code, and also, you know, this comp plan update that's on the table tonight.
Well, no, and I don't want to be misunderstood here. Obviously, we have to gather the public input, and you've done that. The Planning Commission has gone out, you've done your road shows, we've held a public hearing. But ultimately, that decision and the definition lies with, well, in this case, we're not the city council, we're the county, so it lies with the county commissioners. That's the point I'm trying to make. And to avoid us getting into a situation where we have potential pandemonium. But if you feel it's fine as it is, I'm okay. You do? Okay. Good enough. Okay, the only, so we've gone through 1 through 4. Item number 5, I guess, for me, it's primarily a question. Document specific health, safety, and general welfare reasons supporting each land use designation.
Decision.
Excuse me,
Decision,
decision,
yeah.
thank you. Do we not essentially address that through zoning?
We do, but keep in mind that your comp plan should support your zoning. So
Precisely.
this is one of the things that we hang our code on right now today.
And it's already required under state law, but I think this evidence is a commitment to doing that and making sure, you know, that those, you know, the reasoning for the decisions include why this is important to health, safety, and general welfare, or, you know, that health, safety, and general welfare concerns have been addressed, you know, vis-a-vis the potential impacts of the proposed development. And I think we already do a good job of that, but I think that just cements that is the policy of the county, that we will do that.
Okay.
You know, and including, you know, justifications of each land use regulation, maybe not necessarily in writing, but, you know, just an indication that those regulations are justified by health, safety, and or general welfare concerns.
Okay. Anyone else?
I'm good all the way to land use,
Oh,
section 3.
okay, I've got a couple of others. Under the proposed objective 2 for zoning, so I'm still on page 2. This tribe had suggested, and I think it might be a good idea, to add to the verbiage and to protect natural resources and waterways. Would you think that's appropriate?
I would support that. The Planning Commission itself, interestingly enough, added protection of land, protection of natural resources in the very first goal of you know, the property rights element. So, they certainly
Recognized it, okay.
an important goal as well.
I think that's already stated further in the goals and objectives, though. I remember.
It may well be, well, it's.
Yeah, it shows up. So,
Yeah, so, I mean, I think it could be added, and I would support that if that were a decision, but I do think it's adequately covered in the.
natural
update as a
resource
whole.
section, or, yeah. Yeah, and I'm going to actually bring up several places where we just repeat ourselves, and so I would ask that the duplication be limited or taken out.
Bill, thoughts?
No, I'm good with, if it's addressed further on in the plan or the document here, I
Okay,
don't have.
and we'll note that as we
There's
go
no- there's
along,
no
we can
reason
always
to,
come back.
yeah.
Okay, good enough, I'm fine. The next item, number 1, under proposed policies, adopt zoning which reflects current land use and expected future land use based primarily on the concerns articulated by those who own property within the unincorporated areas of Kootenai County. Are we saying that someone who lives in the city has no input?
Not necessarily, and that's why I think the word primarily is in there.
Okay.
I mean, I think the, the people that are directly affected by land uses of their neighbors, et cetera, probably have the greatest stake in, what's going to be allowed and what isn't. At the same time, due process mandates that, anyone who, wants to speak, anyone who wants to be heard on an issue can and must be heard. Because the board acts in a quasi-judicial capacity when it comes to land use permitting, you naturally weigh the credibility of, or even a legislative capacity for that matter, you weigh the credibility of each, person who speaks, and then you make your, decision accordingly. So, whatever, and you each choose to give the weight to any particular person's testimony that you believe is due.
Okay. Leslie, Bill, any thoughts?
Leave it.
Okay, let me just make a comment here, and I'm going to ask you, Pat, to jump in. Zoning, again, is, okay, obviously, people have input. We know that. It's all part of the process. It's part of due process. But zoning, again, is a function of the governing bodies who have the knowledge to be able to put those zoning regulations in place. Is that not a consideration here?
Yeah, it is, I think it is a consideration. I mean, it's not like we've got a vote or a Gallup poll based on, based only on people who live in the unincorporated county. I mean, it doesn't change, the county commissioners or plan commissioners
Okay.
or hearing examiners' duties or, what's expected of them. It's just that, I think just a recognition that the people who live in the unincorporated area of the county typically are the ones that have the greatest stake in any given matter. That's not to preclude people who live in cities. I mean, they may own property in an unincorporated county. They may live next to,
Okay, fair
close
enough.
to something in the unincorporated area of the county, or another city for that matter, and or just concerned about maybe they, support, one, area's desire to, leave their land more rural, where, another part of the county, they may support more development along that corridor, et cetera. So it's not like we're shutting out city residents' voices. It's just recognizing, I think, and respecting the fact that those most directly affected are the ones who live in the unincorporated county.
Right. Yeah, I think where I'm coming from is that there are those, okay, there's the input that comes from the citizenry, but then there's the decision-making process that comes with the elected officials. And that's where I tend to draw some distinction. But, okay, I'm fine. Anybody else on that? Okay, page 3, item number 2. Adopt land use regulations which provide that agency exactions may only be made a condition of permit approval if they are roughly proportional, both in nature and extent, to the impact of the use to be permitted. The concern that I have here, not that I disagree with the statement, Mike, the concern that what did I do with it now? Oh, here it is. Agency exactions can only, okay, right, that are proportional, that's the claim. But we have to remember that agencies also have state and federal statutes that they must comply with. Are we usurping something here?
No, sir.
You don't
This
think
comes
so?
right out of the Supreme Court decisions over and over.
Say that again?
This language is directly related to U.S. Supreme Court decisions that have routinely said that the state agencies you mentioned
Yes.
and any municipality must have exactions that are at least roughly proportional, and better to have proportional.
Oh, no, I'm not
The U.S.
arguing
Supreme
with the
Court
essence
just
of it.
said that that's the starting point. It's got to
Okay.
be at least roughly proportional.
And I'm fine with that. But the question that I have is, if they already have that standard, are we merely repeating it? Or you're saying
Well,
it
they-
applies just as
Arguably,
equally?
they do, but it's, again, it's not unhelpful to have it here.
Fair enough. I'm good. Anybody else on population? I don't have anything there either. Economic development? Anyone have anything? Oh, I'm sorry. Yeah, I don't have anything. Leslie?
Nope.
I think you said you didn't, Bill? Okay. Anybody have anything on economic development?
There's a
Page
nit to
4.
pick on number 2.
I'm sorry?
There's a nit to pick on number 2 under economic development, where it says strengthen.
Yeah, go
county-
ahead.
Just strike forestry, the RY, and just say forest industries would be better grammar.
Okay.
Oh, forest?
Yes.
Okay.
Thank you for picking that nit.
It's easier to clean it up now than us do it afterwards.
Okay. Anybody have anything else? No? Okay, I have a concern with number 1, direct commercial and industrial uses excluding home-based businesses and cottage industries where urban services are available or where sufficient infrastructure is available. Why would you exclude home-based industries, businesses and cottage industries?
Where are you?
Economic.
Under
Number
economic development, proposed policies, page 4.
I think because they're smaller in scale and therefore not in need necessarily of urban services or enhanced infrastructure. Those are ones that, typically can be engaged in without needing, say, city sewer or.
Okay, so the question I have for you then is, where are these defined as being smaller in scale?
In the Land Use and Development Code.
Okay, so if we have a home-based business with employees,
Well, that would be,
It's actually covered in the land use code.
yeah, the land use,
Number of people allowed.
bingo. You
right,
you
yeah, we
answered
have
my
those
question.
gradations in the code.
Okay, fair enough. Okay, let's see. Gosh, I got to go back and forth here. Item number 3, and some of these are merely questions, so determine through a public process the future compatibility of additional commercial and/or industrial development within the unincorporated areas of the county. Okay, so the comment that I would make here, and I'll throw it out to you folks, is using the public process to determine where compatibility exists is not always possible. Any resource industry needs to be at or near the resource, such as, for example, a gravel pit, okay? Not all land is suitable for proposed uses. In some cases, land simply doesn't perk. The current process of a business requesting a zone change is the best process as it pinpoints the area of concern and then allows the public to engage with the business. Final decisions are always based on zoning laws, state statutes, and case law. Comments?
This is meant to get a more narrowly defined area, and maybe some useful wordsmithing would help.
Okay.
But what the Plan Commission was trying to achieve here is we have areas along, for instance, 95.
Go ahead.
That are zoned rural. They probably should be commercial.
Okay.
We have other arterials that have those kinds of circumstances.
Okay?
This is just merely giving us the ability to reach out to the public, have a neighborhood discussion, see if there's support, see if the property owner supports, and then come back to you through a hearing process. It doesn't usurp or preclude anything you said earlier, Mr. Chair, about a regular rezoning. We already have that issue covered, I mean.
Okay.
So maybe something needs to be broadened here to say that in reviewing, I'm making this up as I go. It's
Go ahead, that's
always
fine.
dangerous, but in reviewing future growth in the community, comma, and then add in the rest or something like that.
Okay.
So, I mean, I'm open to suggestions about how you should
No,
use words.
I think that makes sense.
The idea is that we're looking broad brush across the entire county for areas that maybe need some reconsideration in current zoning.
I'm fine with leaving the language, that's what I understood it to be, so.
Bill?
I agree with Leslie, but if there's something that David thinks we should, or the director, I'm sorry, thinks that we should
Do you
do
think it
to-
needs any wordsmithing, or are you okay
Yeah.
leaving it as is?
I think it's good enough, frankly.
Pat?
I think it's perfectly fine.
Okay,
Okay, that's good.
done.
And we couldn't change zoning without what the public process anyway.
Yep.
Okay. Anything, Leslie, I think you had something for land use?
Yeah, under objective 3. So do you have anything up to 3?
Yeah, I do.
Okay.
On proposed land use, okay, so under proposed land use, objective A, rural character, proposed policies, page 5. Determine the public's definition of rural character and use agreed upon rural character principles.
Are you reading there? I'm sorry.
Yeah, I'm sorry, I'm reading off
What number?
Page 5,
page
Page
5.
five.
Under proposed policies, item 2.
so at the bottom of
Here.
the page,
There you go,
right?
Or
above
here.
the- Yes,
determine.
down on the bottom.
Okay, good.
Okay.
Go ahead.
Determine the public's definition of rural character and use agreed upon rural character, and use agreed upon rural character principles. Are we missing a word there, or is it me? And or standards to review zoning and land use regulations. Okay, where I have an issue here is, and again, when we go to the public, obviously we need to do that, but if I ask 5 people, give me your definition of rural, I can get as many different definitions. So this is where I have an issue here. And so the public really, and somebody made reference to the Keziah-Watkins study here, and I think it's interesting, somebody said we shouldn't use it because it was done by foreigners. And when I read it, I said, I didn't know that Keziah-Watkins were from Pakistan. But there were 1,400 residents in the study, but that's beside the point. And essentially, there were a lot of people in there, and they wanted to preserve the rural character. So I guess what I'm saying is, I think this is really resonant with, yes, we get the public input, but to say that it's going to be determined by the public definition, I think is wrong. That needs to be reworded.
No doubt that this is a case where syntactical amendments are necessary. It needs to be rewritten, but to help you with this one, I know what the Plan Commission is trying to achieve. which is
Right.
that we don't have a community idea of what rural character is. That's all we're trying to get at.
Right. And that's for us to define. We can gather the
Ultimately.
input, but ultimately, it's for us to define. Yeah,
Yes, sir.
okay. Where was yours again, Leslie? Bill, do you have anything?
Nothing.
Mine's at the bottom of page 6, under objective 3, number 1.
Okay. Okay, I'm on page 6, proposed policies.
Yeah, but down under land use objective 3.
Oh, okay, yeah, I've got something
Single-family
above
multi-
that. Okay.
Okay, go ahead.
Item number 4, under proposed policies, it says, allow to the greatest extent possible rural property owners reasonable economic opportunities for the use of their land. I would strike greatest extent possible. Once again, you know, we're opening the door to massive development, and if you're going to do that, should they be in a commercial zone? So I would just strike the words greatest extent possible, so it reads, allow rural property owners reasonable economic opportunities for the use of their land. You with me?
Yeah, I just wonder how much, be interested from Pat's point of view, how much that would make a difference in what that sentence would permit.
Well, I think, assuming greatest extent possible were left in, I think it would be up to the board in subsequent land use applications or, proposed ordinance amendments to determine both what, reasonable economic opportunity is and greatest extent possible. And it doesn't necessarily mandate a conclusion in any given case that they say, get commercial zoning when their zoning had been rural, as an example. So I'm kind of neutral on this one. I think it can be left in. I think it can be taken out.
So let me go back to the point that I think David made earlier. If this is addressed in the land use code, and the greatest extent possible is somebody with employees, you're saying we're already covered?
Yes.
In that example, yes. But this is really a judgment call by the board. If two of you would like to strike this one, I'd go for it.
I would strike it.
Go for it.
Well,
Ultimately, this needs to reflect your
yeah.
opinion of these things.
My opinion is to the greatest extent possible.
I think a lot of these policies and things, people get carried away with a lot of verbiage that they think means something special that in fact doesn't. And when that happens, it gets confusing. So I am for striking as much as possible out of here of that, what I consider to be not illegal or extra legal, superfluous language pretty much. So here it would say, allow rural property owners reasonable economic opportunities for the use of their land.
Okay. So strike, right?
Yes.
Okay. Leslie, did you have something on the next section? Areas of city impact?
No, down in the single-family, multifamily residence.
Okay, I've got one more. Under proposed land use objective areas of city impact, item number 4, encourage industrial and commercial development to occur within cities rather than in ACIs. If you go back to item 4 above that we just addressed, we might have inconsistency there, because if you're saying to encourage industrial development within the ACIs are in the county, and later in the same document it says that we ought to be encouraging commercial development in the cities. So I think what's happening is we're getting a little inconsistent.
I don't see it that way. The reason is ACIs are special areas that are called out for protection of city interests, whether it be future growth, watersheds, et cetera. In the case of future growth, I think that's seminally important because you don't want development in those fringe areas to be incompatible with their development pattern. And, to be honest, industrial and commercial development is, of that scale is most likely going to need city sewer services
Yes.
and municipal water and et cetera. Especially industrial development, because they have non-domestic wastewater standards they have to meet.
Okay.
Panhandle Health District, and that's best accomplished by annexation into the city. So I think it only applies to ACIs, doesn't apply to the rest of the unincorporated county. So I think the overriding policy of allowing rural property owners reasonable economic opportunities for the use of their land is still very much valid, but just within the ACIs recognizes that there are countervailing city concerns that
Okay.
come into play.
Fair enough. Bill, Leslie, you're fine?
Yep.
Okay. I don't have anything else on that page.
So this is more of a question under Objective 3, proposed policies. Number 1, establish where warranted various rural residential zones after reviewing existing zoning, parcel sizes, development history, density, access, hazardous areas, infrastructure, and the need for regulations. Does this open us up to down zoning, problems that we had with the ULUC? What is the purpose of having this here when we already have zones? Why do you need to further?
The thinking by the Plan Commission was to look broad brush across the county at our current districts and our current need. There's some concern that they don't match up. One of the things that I bump into routinely is our highest densities are around the lakes. And that's
Restricted residential.
contrary to what common sense would suggest ought to be good planning practice, because it concentrates impacts around our most critical
Sensitive.
resource. So that's the kind of thing the Plan Commission just wanted to be able to look at. And for instance, again, right now we have various levels of allowed use within several zoning districts. If it's less than X amount of square feet, you can have such and so uses. Another size, some more uses, so on and so forth. The thinking again here is that we take a broad brush look across the county. Is there a more practical way to get at these things?
The other thing I mentioned is that the concerns regarding downzoning and its related issue, nonconformities, is addressed earlier in the plan. It specifically calls on the county to avoid downzoning and also to avoid creating nonconformities, to try to ideally, make nonconforming properties conforming, or at the very least not increase what, the nonconformities that are there.
Okay. Yep.
Anything, that was page 6. 7?
I do. I have one on page 7.
Go right ahead.
Objective 4, policy number 2, on Director Callahan's letter to us, November 7th, 2019, it said that this section was going to be changed, and it is not changed in our most recent September document. So I would prefer it to say subdivision development in rural areas should be designed to voluntarily preserve where warranted open space, resource lands, and wildlife habitat, rather than kind of the way it's worded in the current. Is there a reason why that wasn't changed, or is it just missed?
Probably because we hadn't had direction to do it. So you would take out in parentheses the 50 or more.
No,
Yeah,
is that what you're saying?
yeah.
Designed to voluntarily preserve.
Right.
Right.
Yeah, I definitely think that part of it is appropriate and should be done.
So this was from the,
It doesn't change, it doesn't change the substance of the policy.
right. Well, this was changes supposed to be made from the September 26th public hearing.
So we just missed it,
Yeah,
if that's the case.
yeah.
That wasn't necessarily my understanding, and I may have misunderstood, but we can certainly, if we get at least one other commissioner to agree to that, we can certainly do that.
So did we,
So my understanding from this letter dated November 7th, it outlined all the changes that were made from September 26th. But this change didn't make it into the final copy. All the other changes did. I went through every,
Well, there's only two options. Either that paper was flawed or this one is. You have to just choose which one you want.
I think I prefer the change that the Planning Commission agreed to on November 26th, or September 26th.
I respectfully disagree. If I'm a developer, why would I do anything voluntarily? Think about it. I'm out to make a buck, and that's okay. That's what he's in business to do. But once you insert voluntarily, it's probably not going to happen. So what's the intent? You know, if we're looking to preserve, you know, resource lands, wildlife corridors, and by the way, it does actually say, and voluntarily open
Open
space.
space,
So we do have a measure of voluntariliness there. So I think it would actually get redundant if we put it in again.
I would take that voluntarily.
You would take the second one
Yes,
out
I
and
would
put
just
that
move voluntarily into the front of the list instead of the last item on
I
the list.
see what you're saying, so that, not me, but that's why we're a board.
Read what is the change, Leslie, that was done?
So it was changed to read, subdivision development in rural areas should be designed to voluntarily preserve, where warranted, open space, resource lands, and wildlife habitat.
I would agree with Leslie on this one.
You want to go voluntarily?
Yeah.
Okay. You sure?
Ask me again.
Well, I'm just telling you that from years of being in the business and witnessing, how do I put it?
Once again, these are not laws. These are not laws.
Yeah,
We
but it
already
is
have
an
laws in
umbrella
place.
document, okay? And I think it does carry some weight. Maybe you guys ought to comment on that.
Unless, we have two members of the Plan Commission in the audience. Normally, we get these things right in the staff write-up that goes forward.
I don't have my official records, David, but Wes and I remember that the voluntary was really referring to open space,
Only?
because that was what we heard in the public hearing. We changed, we took out view sheds and a few others, and we put voluntary where open space was, is what we remember, but I don't have my official records. So really, it's a question of what.
Well, how about this? We could certainly pin down what the Plan Commission did in our files, and if you're willing
And
to
get back to
go
us.
forward with whatever the
Yeah,
Plan
that's fine.
Commission did on this item, we could do that.
I'm good with that. You okay?
Yeah.
Unless you want to back me up solidly.
No, I think we should do what the Planning Commission recommended here. And if we don't have it in front of us, you can't very well do that. It needs work.
So you want staff to check on the planning commission?
Yeah,
Okay,
that's
fine.
simple and fair.
I'm okay with that. Okay. Anything else on proposed land use objective 4? Was that it? Moving on to objective 5, commercial development. I guess I just have a broad question here under proposed land objective 5, commercial development. The question that I have is, are we also potentially allowing for industrial development?
Under number 1? Is that your question?
Yeah, it's essentially that whole section.
Well, we kind of already addressed that we prefer industrial to be in the cities.
To answer your question, Mr. Chair, it's commercial,
And not industrial,
Right.
yes.
okay?
I would say industrial if we meant it, but we
Okay.
shouldn't under the commercial
Well, no,
development
because
section.
sometimes commercial is used generically, and I want to make
It
sure.
shouldn't be.
Okay,
In this case, in this context, nor in the land use code, we expressly differentiate.
got it. Okay,
And the next one is industrial. so
Yeah, there
then
you go. Go
There's
ahead.
my argument made in full.
only where appropriate, where is that addressed? Is that in the land use code?
Yes, sir.
So we're covered?
Yes, sir.
Okay,
And if I may, while we're on this section,
yes.
under number 3,
Mhm.
I think it'd be useful if it read, require mineral extraction / mining operations to provide a plan which includes a description of the area and material to be mined. Because material is often a significant issue in a CUP process or any other review of mining.
And
I'm fine with that.
area and material? Yes. I'm fine. Okay. I don't have anything, or by the way, does anybody have anything on 7 or 8?
I have 7A.
Go ahead.
The first one, review areas where land use development has negatively affected water quality or quantity and use this information to determine other potentially affected areas. Is this scientific? Is this anecdotal? Is this, what kind of,
Arguably both. At the moment, it's open to those things. And ultimately, Plan Commission recommends you adopt. So if you thought it was merely anecdotal and that's not sufficient, you would presumably dismiss it.
Okay, that's fine. So we leave it alone?
for now?
Okay. Bill?
I agree.
Okay. So that's it for number 8. Is there anything on number 9?
Top of page 9, second proposed policy, support the adopted Coeur d'Alene Airport Master Plan. That's just one of the duplicate things. We have a whole section at the end on supporting the airport and its master plan. So I'm not sure how much duplication, you know, if Bill's looking to get rid of all duplicate language or unnecessary language, I would suggest that one. I'm not sure what the purpose is.
Is that adequately covered later in the document?
Well, we could look.
It's the last page, last section.
I believe it would be.
Public airport facilities?
Yeah. Support the Coeur d'Alene Airport Master Plan and protect the airport's future operation and the health, safety, and welfare of the general public.
There it is.
Agreed.
Strike it?
Yeah.
I guess that's all 3 of us, okay. You're quiet. You guys okay over there? Mm-hmm. David? Pat? Okay. Anything on the next, on zoning?
Yes, so under proposed objective 3, there's a bunch of things in here that are also duplicates. So I'm not sure if we want to go and do that, or, I mean, does it?
What are you saying?
So, for instance, number 1 is a duplicate from 7A.
You mean maximize those uses permitted?
The negative effect of water quality or quantity and use this information to determine other affected areas. I mean, it's already said in 7A, number 1.
Okay.
So, I mean, you're using a little bit of review versus inventory. I mean, I guess if you have a purpose
Which one are you on again?
differently. I'm on objective 3, proposed policy, number 10.
What page is
Page
that? Oh, you're out ahead of me. Okay, I
Yeah.
had a couple, that's okay, go ahead.
So if you're just using different verbs there, you know, I suppose we can just leave it in. I just was curious as to, under objective 4, again, the number 2 is also duplicate.
Determine areas adjacent to water bodies?
Yeah. Well, I'm sorry, number 2 on under 4. So, I think that's probably something we can address later.
Yeah. Okay. I mean, we don't want to be redundant, but there's some things that where a little emphasis probably doesn't hurt. Bill, did you have anything there?
No.
Leslie, you're okay with
Yep.
that then?
Yeah.
I just want to go back, if we could, to page 9, proposed land use objective 9, zoning. Proposed policies maximize those uses permitted outright in zoning by specifying all conditions or standards that must be met. when we talk about listing all the conditions, I wrote some of this out, by the way, for conditional uses, as the county and the people, this is me speaking, the county and the people of this county don't have a crystal ball into the future. To list permitted uses outright or come up with specific standards when each property and condition is unique would open the county up potentially to lawsuits. Are we putting too much in there? Are we putting ourselves in a position of something that we can't necessarily achieve?
Well, to me, it just seems duplicative.
I'm sorry?
It seems duplicative to me, kind of dovetailing off of Leslie's comments. That's one I think we could just take out completely.
Strike it?
Yeah,
Okay,
only because of duplication, we've already addressed that.
understood. Leslie, okay?
Yeah.
Bill? Okay, strike. And then item 3, that same section, proposed policies. Well, I guess I'm kind of saying the same thing, but list in applicable zoning district sections all applicable conditions or performance standards required for conditionally allowed uses. Is that doable?
I would just,
Strike.
take out the words "in applicable zoning district sections" and just say, list all applicable conditions, et cetera.
Take out the
Okay.
word, say that again, Pat?
List all applicable.
Take out the words "in applicable zoning district sections" to where it would say, list all applicable conditions and so on.
Okay, fair enough. Leslie, you
I
okay?
agree.
Yep. Bill?
Good.
Okay. Does anyone have anything else?
I have page 11,
Page 11?
number 4, kind of in the second third of the page. Create a series of educational handouts, pamphlets, public distribution which identify hazards in various areas and suggest ways to voluntarily minimize them. I'm just curious, is there a reason why we would have that in a comp plan?
Good question.
Yes. Again, it's a policy matter, and the thinking is that this is useful for the public if we do these kinds of things. And this authorizes the staff to attempt it, bring it through the Plan Commission, and bring it to you.
Okay. It's fine.
Yeah, I think it's kind of the Fram oil filter conundrum, pay me now or pay me later.
Sure.
If we can educate them now, we might, avoid a code enforcement nightmare later.
Okay.
That's fine. So a question on top of page 12, which is underneath the public services, facilities, and utilities. Number 2, supply public service providers with population forecast, development plans, and technical data. Is that our business? Is that, don't we
Yes,
get
it
from
is.
somewhere
And they
else?
should do the same for us.
Okay, so it's a
That's how we
reciprocal.
play nice in the sandbox and do better land use planning.
Okay.
All right. All right, and then the shaded box, I'm actually almost done, I think. Oh,
You
I
had some
lied.
com-
I think that the proposed goal transportation, to coordinate with and provide input to local highway districts, state agencies, and other departments to ensure safe, efficient, take out the word public, transportation while protecting and enhancing where appropriate the county's economy, environment, neighborhood quality, cultural, and scenic values. That, to me, it broadens it because transportation is everything. It's bicycles on, cars and that kind of thing. So to kind of limit it to public transportation, I think we need a broader thing there.
Yeah, David's agreeing, and I agree. Saying safe, efficient transportation includes both public and private transportation.
Bill, anything?
No, I agree.
Got more?
Well, I have a question on page 13. The special areas or sites, are these county-owned, or these are just, could be privately owned sites, structural, geological, anthropological,
Yes, it could be both,
both?
or
Okay.
either.
Okay.
Where was that?
Page 13 in the middle.
Oh, okay. Right there, okay.
Yeah, well, just the whole
That whole thing?
Yeah.
Okay.
All right, now I think, let's see. Page 15. Near, under implementation, proposed
Yeah.
policies, add an addendum to the comprehensive plan in which various element goals, objectives, and policies are listed and assigned to appropriate parties to implement with a specified time period. Who are the appropriate parties?
Catch me up where you are.
Sorry about that. Page 15, about the
Yeah.
third paragraph from the bottom.
Proposed policies, number 3. Yeah, what are you trying to say there?
Trying to remember where we landed on this one.
I'm going to recognize Dave Levine. Go ahead, Dave.
The purpose of this one was to hold accountability, is that we wanted to take all the information that was in here and make a grid, and the accountable people could be someone on David's staff.
That was it.
could be the planning
Okay,
commission,
okay.
But we wanted the public to know, we just didn't do this to put on the shelf. We did this to be actionable, and we wanted to hold ourselves accountable. So this was just a grid, of accountability grid, and we don't know who's responsible.
Okay.
We haven't done it yet.
Would normally be staff, my staff, but it's conceivable there might be other agencies involved.
Okay, I'm fine for now.
Bill? You okay?
That's all I have.
Bill, do you have anything?
I have nothing more.
Neither do I. So, council, if we're going to structure a motion, can we do it, how do I put this? Where we don't have to cite every individual change, but note the fact that, I guess Kathy's been taking notes, is that correct, Kathy?
Talk about tentative.
I have been.
You want to help us out here?
I've been doing underlining and strike through as we go along, so I have it.
Okay.
as well. But I think, to answer your question, I think the motion would just, the comp plan update as recommended by the planning commission with the
Amendments?
with the changes that have been agreed to by at least a majority vote tonight in tonight's deliberations.
Okay.
Where's that effect? Is not exactly that, but just as long as it gets the idea across that it's as modified by either unanimous consent or at least a majority
Okay.
of the commissioners.
Should the motion include retaining the 2010 comp plan as an appendix?
Yes.
Okay.
And, I would also ask to make the future land use map a separate section as well.
Oh, okay.
I have it all written down.
Okay. Are you ready?
I am. I do want to make a statement, though. I think some of the wording that was taken out, some of the changes were made. I think it makes it more like we're not as concerned with property owners as we should be. I liked the original approved language that the Planning Commission set forth. So I am not going to vote against this because I think it is an incredible effort, and I appreciate the effort that was put involved, and I'm much happier with this than where we came from, where we started from. So just wanted to make that statement. All right, might take me a couple tries, but I'll make it work. I move that we approve the updated comp plan as a primary section with the land use code being broken out and the 2010 comp plan being an appendix.
Future land use map.
Future land use map broken out, and then the 2010 comp plan being in an appendix. Minus the goals and policies. And that staff continues to make those necessary changes that are grammatical in nature, and incorporate the changes that were agreed to tonight.
You're fine.
Perfect. Oh, I second the motion.
Bill Brooks,
Aye.
Commissioner Duncan,
Aye.
Commissioner Filios.
And so, before I vote, let me opine. I think I'm going to some degree, respond to Commissioner Duncan. I understand where she's coming from, but I'm a firm believer that with rights come responsibilities. And in my family, not just in the real estate business of selling, but appraising, literally thousands of properties, there is a lot of abuse. And the abuse, yes, it's a minority, but that minority can have a major impact. It's just like you can't shout fire in a crowded theater. With every right come responsibilities, and I think that's what we're trying to do here. We're trying to build in something that's going to work for the greatest number, and essentially that's where I come from. And so my vote is also yes. So the motion is carried.
Motion is carried. Approved.
And the time is 7:13 p.m., but we do have to have public comment. Do we have any public comment? Yes, sir. Yeah, by all means. I'll give you 3 minutes.
I've said it before and I'll say it again. The process here is backwards. You
Please,
have
go ahead.
adopted policies and goals with no analysis. Period. They ain't any. They ain't there. So the question of it is, your goals and policies are capricious. They're just selected. You went through the plan and pick, with no analysis. Now you're going to do, now you've got goals and policies, and you're going to do the analysis. It's backwards. That is total backwards. But I guess in Kootenai County, we like to be backward. That's all I can say. You know, it just,
So
no, I'm just saying,
well, let me
that's
ask you a question. Do you feel that even with the inclusion of the 2010 comp plan as an appendix, that it's still backward?
right, because the policies that are selected, this is a rewrite. This is not an editing. It's been rewritten. It's a rewrite. And I think if this can be established by the document that you could show it. And KEA did an analysis of it. It's a rewrite. It's not not editing. So the question of it is, we got all these policies. Now you got to give them a basis for their validity. You start with an analysis and a basis you got, and then you say, now what really makes sense is policies. It's backwards.
Okay.
And I'm just saying, the only way you can do it is you need to, for awful, start all over again. And I don't think you want to do that. Well, I'm just saying, I guess we like to be backward.
Thank
I
you.
don't know, I'm just saying, and you, in the backwardness, you're going to create policies or analysis that justify this. Maybe what if the analysis doesn't justify this?
Then we'll change it.
Yeah.
Well, then it gets to be really more of a hassle. It really gets to be a hassle.
Well, it has to be revisited periodically anyway, so, and that's by statute.
But it'd be interesting if we started, the proper way.
Okay, your points are well noted, thank you.
Thank you, Art.
Okay, whatever.
Anyone else? Jeff?
I'm a little slow. I got a new knee for Christmas.
Okay, that's all right. Take your time.
I just, it's been a long process from the beginning and with the planning and zoning that I've been involved with. And I would just like to thank all of those commissioners and you guys for being as transparent as you were.
Thank
and
you.
Also inviting the public to all these meetings. There's been ample opportunity for the public to be involved in this. You know, as president of the NWPOA, we tried to reach out to our members to be involved, and so we reflected our members in this too, and I think we came to a conclusion here tonight that is close to what we could have asked for. A lot of good changes, positive changes. I of course kind of agree a little bit more with Commissioner Duncan
No
tonight.
surprise.
Because the primacy was one of the things that I kind of fought for with the Planning Commission. But I'd like to thank all of you involved, and it's been a long process, but I'm happy with the way it turned out.
Thank you, Jeff. Anyone else? No? I have 7:18.
7:15, 16.
I stand corrected. 7:16, meeting adjourned. Thank you very much.